This is Barry Zalma on insurance. Today, I'd like to speak about the evidence needed to prove insurance fraud. Evidence for the purposes of proving that someone has attempted or actually succeeded in committing insurance fraud is broken into two major categories: direct and circumstantial. Direct evidence is proof that tends to show existence of a fact in question without the intervention of the proof of any fact. It includes testimony that tends to prove or disprove a fact in issue directly, such as eyewitness testimony or a confession. Sometimes direct evidence may not exist because records have been destroyed in a fire, destroyed by water, stolen, discarded, or even eaten by vermin. If direct evidence does not exist for any reason, circumstantial evidence must be produced to prove the fraud. And as important as direct evidence is to the proof of fraud or attempted fraud, as courts have noted in the past, it can be difficult to obtain direct evidence of something so internal as an intent to commit fraud. Jurors are therefore free to consider circumstantial evidence and draw reasonable inferences from it. For example, in United States v. Hawkins, a Sixth Circuit decision in 2019, circumstantial evidence was found to be sufficient to allow a jury to convict a crime of insurance fraud. Circumstantial evidence is all evidence of an indirect nature when the existence of the principal fact is deduced from evidentiary facts by a process of probability reasoning. The investigator takes circumstantial evidence and uses deductive reasoning to reach a conclusion. Circumstantial evidence and the deductions of a professional investigator are often more reliable than direct evidence like eyewitness testimony. Circumstantial evidence is sufficient to establish proof of arson and other criminal activities. Many fraud cases are proved entirely by circumstantial evidence or by a combination of circumstantial and direct evidence, but seldom by direct evidence alone. Fraudulent intent, the most difficult element to prove in any fraud case, is usually proven circumstantially, and necessarily so, because it's impossible to produce direct evidence of the defendant's state of mind, absent a confession or the testimony of a co-conspirator. In a circumstantial case, the court may instruct the jury that the prosecution, in a criminal case, or the insurer in a civil fraud case, must exclude all inference from the facts other than its determination of fraud. If the trier of fact can infer a legitimate rather than fraudulent explanation for a series of events, the insurer's defense or the prosecution will fail. Even if no such instruction is given, the investigator and adjuster should apply the same standard when preparing a circumstantial case for trial. Occasionally, as in the Indiana case of Hicks v. State of Indiana, a 1987 decision, a thief will attempt to defeat a burglary claim by claiming it was part of an insurance fraud scheme. If the victim instigated the crime as part of an insurance fraud, there can be no conviction for burglary. However, adjusters, like the prosecutor in the Hicks case, should be leery of such confessions, as they may often be fabricated. An insured should never be accused of fraud based on an accused felon's statement unless independent, innocent witnesses corroborate the felon's charges. In the Hicks case, the court found appropriate cross-examination on the fraud claim and affirmed a 30-year sentence by stating, quote, "During cross-examination, the prosecutor asked Smith if he created the story of insurance fraud scheme on August 14, 1982. Smith responded that he had not, and stated that the scheme had been planned prior to August 2, the date of the burglary of the Robbins home. The prosecutor then offered into evidence State's Exhibit Number 38, a letter written by Smith to appellant on August 14, 1982, in an attempt to discredit Smith as a witness. Cross-examination is permissible as to the subject matter covered on direct examination, including any matter which tends to elucidate, modify, explain, contradict, or rebut testimony given during direct examination of the witness. In W.L. Lindemann v. Strange, a 2000 court decision from Texas, the court noted that fraud is usually so covert or attendant with such attempts at concealment as to be incapable of proof other than by circumstantial evidence. In a suit against an insurer can never be too well prepared. In a Utah case, an insurer recognized that it was not a favored litigant, presented over 200 pages of documentation detailing the extent of its damages and the grounds for its summary judgment. The Court of Appeals in Amica Mutual v. Shetler, a 1989 decision, affirmed a summary judgment in favor of the insurer for fraud and awarded compensatory and punitive damages to the insurer. Some guidance is offered by trial courts which have articulated several factors as indicia of a non-accident or fraud, including 1. More than one collision with a short time of the policy inception, 2. Cancellation of the policy shortly thereafter for non-payment of premium, 3. Similarities among the collisions and interrelationships among the parties, and 4. Inconsistencies in testimony regarding the circumstances of the subject collision and the identities of the individuals involved. Such factors in various combinations have been held to constitute a compelling and persuasive body of circumstantial evidence that the underlying loss resulted from an intentional collision staged for the purpose of insurance fraud. Some courts require clear and convincing evidence to uphold a fraud allegation. The clear and convincing standard is a very difficult and stringent standard to establish. Some courts refuse to accept the clear and convincing standard of proof proposed by the plaintiff in an insurance fraud defense, pointing out that the proof of fraud by a preponderance of the evidence, that's 50% plus 1, which is much easier to establish than clear and convincing evidence, renders the insurance policy void from its inception. As a New Jersey court once stated, this court has previously addressed the nature of the arson defense and the quality of the evidence necessary to support the defense. The arson defense is most accurately viewed as an allegation that the insured purposely created the loss and therefore should not benefit from it. To succeed on a defense of arson, an insurance company must show by a preponderance of the evidence, 1, that the loss was due to a fire of incendiary origin, 2, that the insured had the opportunity to set the fire, and 3, that he had a motive to do so. It matters not whether the jury determines the insured personally set the fire or did so through the acts of another. The key is that the insured caused the fire to be set. The notion that a defense of arson can be defeated by a failure to prove that the insured himself was the incendiarist just doesn't work. If sufficient facts are present, it is easier to prove rescission than an accusation that the insured committed the criminal act of insurance fraud. Rescission in many states can be had even if the insured had no intent to defraud the insurer and no intent to misrepresent any material facts to the insurer. All that is needed is to prove that the insurer was deceived. To prove the crime of fraud, on the other hand, the prosecutor or the insurer in a civil court is required to prove an evil or criminal intent. Evidence of prior claims, whether fraudulent or not, are admissible to show motive, intent, means, and opportunity to commit insurance fraud. When plaintiffs make claim under the Florida Civil Remedies for Criminal Practices Act, which provides that any person who proves by clear and convincing evidence that he or she has been injured by reason of any violation of the provisions of a Florida statute, Section 772.103, shall have a cause of action for threefold the actual damages sustained, and in any such action is entitled to minimum damages in the amount of $200. This includes insurance fraud as is defined in Section 817.234, Paren 1, close paren A, close paren 1 of the Florida statutes. In Didona versus State Farm Mutual, a 1999 decision of a New York appellate court, the court employed the clear and convincing standard in conformance with insurance fraud cases in New York. Nevada provides both statutory and common law remedies to check insurance fraud. Moreover, punitive damages were available under Nevada law if a jury was to find clear and convincing evidence of fraud or misrepresentation. Insurers also were able to rely on the statutory fraud provisions when they were the victims of fraud. RICO, the Racketeer Influence and Corrupt Organization Act, can be applied in harmony with the state's regulation of insurance fraud. Now, it is always necessary to prove the fraud by at least a preponderance of the evidence. An insurer need only prove arson by a preponderance of evidence where the defense of arson against a fire insurance claim is established if it is proved by a preponderance. That's 50% plus 1. The United States Court of Appeal for the Third Circuit held that in New Jersey, a defense based on fraud in an insurance application must be proved by clear and convincing evidence, but distinguished the arson defense and indicated that the defense only needed to be proved by a preponderance of the evidence. Finally, to prove fraud, it is necessary to show that an evil intent, sometimes called Scienter, is involved. The essential elements of the offense, evidence of similar frauds and misrepresentation, are admissible at trial to prove the Scienter element. The insurer need only demonstrate that the facts elicited during an investigation that support the founded belief that a fraud was attempted. Circumstantial evidence is sufficient to prove such facts if a party's conduct may be reasonably inferred based upon logical inferences to be drawn from the evidence. In Mutual of Uniclaw versus McBride, a 1983 decision of the Oregon Supreme Court, the court held that the clear and convincing standard of proof generally applicable in fraud cases does not apply to proof of misrepresentation under an Oregon statute. In that case, the Supreme Court noted the purpose of the statute is to discourage insurance fraud, and the purpose would be thwarted with a higher standard of proof. That purpose would also be thwarted if the Supreme Court was to adopt a Scienter element that is more difficult to prove. As was said about common law fraud, the element of Scienter as an element of actionable fraud is imputed when the statement is attended by reckless indifference to its truth or falsity on the part of the one making it. The Supreme Court could see no reason to make insurance fraud more difficult to prove than common law fraud. This video was adapted from my book, Selma on Insurance Claims, Part 110, the 10th volume of the 10-volume treatise, Selma on Insurance Claims, which is available as both Kindle books and paperbacks from Amazon.com. If you found this video interesting or useful to you and your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel and my Rumble channel, and click on the like button or the Rumble button as you view the videos. And also please subscribe to my blog and my Substack publications so that you can be advised of future videos and future publications on insurance law, and insurance fraud. Thank you for your attention.